This is The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters. A better understanding of the law puts you in a better position to decide how to help yourself, your family, and at times your business. We continue to present various topics, and sometimes you may find that you can handle some issues yourself. Our goal, of course, is always to help you be better prepared, and if you decide to select outside professional counsel, you'll help them too. We hope to save you time, money, and of course, as always, to achieve the best possible results. Once again, and as always, we want to welcome and thank Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to weigh in on the various topics that we discuss. And today, we're going to discuss recent Supreme Court decisions. This is certainly, as of this taping, a very active time, and there was breaking news even earlier this morning prior to this taping. There are some blockbuster decisions that are coming down, and one this morning, a few hours ago, I guess, on affirmative action. There's such a wide collection of topics that they've handled, whether it's affirmative action, student loans that have yet, as of this taping, to be decided, things about arbitration process, overbroad language of how issues are being presented. So as we looked at this quickly in the past even week, we wondered, how do things actually get to the Supreme Court? There's a variety of topics that they've tackled. So David, let's get a quick tutorial on how does something reach the Supreme Court of the land anyway.
So of course it depends on what type of case it is. Certain cases, there is a right of appeal, or there is a actually original jurisdiction within the Supreme Court. But for most cases, and most of the cases that you have talked about where they've just decided them, they get to the court by what's called writ of certiorari. So what happens is a case is heard at the trial level in the U.S. District Court, and then it's appealed to the Circuit Court of Appeals for that particular district. And then if the one party or the other wants to take that case to the Supreme Court, they file a writ of certiorari, which is a claim of appeal, so to speak, or a writ to the Supreme Court to say, please hear our case. They don't take most of those cases. In fact, they take very few. So when a case where writ is granted, where the writ of certiorari is granted and the Supreme Court will hear the case, oftentimes court followers, commentators will say, oh, they took that case. Maybe they want to change the law on something or whatever. You never know exactly what it is or what they're going to do when they take a case, but that's how most cases get to be heard in front of the Supreme Court.
I read something about it has to be about constitutional law, not only, apparently. How does that work?
So the court's going to look at a number of things before they take a case, or they may take the case and address those things. But for example, do the parties that brought the case have standing to bring the case? So if it's the case like you were talking about a little bit earlier on the college admissions policies, do the plaintiffs have standing to bring the case? So first, that's one of the things they may address or may not address if they are satisfied that there is standing. What are the issues that are raised in the appeal? Are they constitutional, U.S. constitutional type of issues that are either equal protection or First Amendment or Second Amendment, those types of things? Or do they involve a statute, a federal statute that's involved? So those are the things they have to look at to make sure they have jurisdiction. There are other areas of jurisdiction. For example, in a trial at the district court level, the case may be brought there based on diversity of citizenship and the amount in controversy. So there are other ways of establishing jurisdiction on cases that may have non-constitutional or federal legal issues, but are otherwise properly before the federal court as opposed to a state court.
I know we may have a chance to talk today about an immigration decision that was recently made. I also found one that was about Jack Daniels and a company that was using or not using properly one of its icons, and that didn't seem that it would be likely to reach the Supreme Court. Didn't seem like it was a constitutional issue, but it was a trademark issue.
Right. So trademark is governed by federal law.
Federal law.
So that's absolutely within the jurisdiction of the Supreme Court because it's a federal statute that's involved.
So once something reaches the Supreme Court, how long does it actually take before a decision's made? We know that they have a schedule, they have a docket, and there's a process within this. So how does that play out, David?
So typically what happens is the certiorari petition is granted, and then the case gets docketed to be heard in the court, and there'll be a briefing schedule. So the parties to the case have an opportunity, a requirement, to write briefs as to their position on how the case should be decided. And those legal briefs are really actually very detailed, and how even the font that you use and how they're bound by
Really?
For the court to see, and how many copies you have to file. There's rules for all of that. So the party that's the, say, appealing or appellant probably files first within a time frame, and then the appellee, the party whose case was appealed, has a time frame to respond to that brief. The court may also invite, or other folks may ask, to file amicus briefs. Those are friends of the court briefs that someone has an interest in the outcome of the case, or a group, or whoever it is. If the court chooses to allow them to file a brief, there'll be a briefing schedule for that. After all the briefs are filed, there's a oral argument schedule that's get put on the docket. And so the parties get to go in front of the court and argue their case to the Supreme Court. And then after that's done, there's usually a conference of all the judges. So they take a vote to determine how it might come. If one side or the other has a majority, the writing of the opinion will be done, and then they'll circulate that amongst each other to try to bring others to their side. If there's a dissent or a majority on the opinion, they try to reach as big a consensus as they can, and so they'll circulate those drafts and maybe accept some amendments to it if it might bring another justice to their side.
So might this be a year-long process from the time they agree to take the case till the time that it's decided? Could it be longer?
It could be, and it really, the time frame for the year-long thing would be that the case is docketed for argument and then the decision, because the court tries to write the decisions by the end of the term, which is coming up. Although the new term starts in October, this term will end, and they want to have all the cases that were argued before them, the decisions entered before they end the term.
I read somewhere that there may be 10,000 requests submitted, and I don't know how many cases, 60 that might be heard or whatever. It did seem reasonable that if someone is presenting a case at the lower level courts and then there's appeal, is it true that each time there's an appeal, there is more supportive documentation submitted by each side, whoever the sides are, and then by the time if it reaches the Supreme Court, I read that you lawyers have a book, a little book.
Oh, definitely. And so what happens, obviously, at the trial level, it's a trial. So the evidence is presented and the exhibits are entered into court, and all of the typical things that go along with the trial are done at that level. Then when it's appealed to the Circuit Court of Appeals, there's the same type of process, briefing and oral argument, and perhaps a rehearing on oral argument if one side or the other doesn't like the way it comes out. And then that usually might be for a smaller panel of the circuit, and then you might ask for a hearing before the whole circuit. And then after all of those remedies are exhausted, if you file your writ of certiorari and it's granted, you're starting that process over with new briefs and arguments for the Supreme Court.
So that's quite a long process.
It is a long process.
And I guess it's intended to be. So it would seem that as long as that process may be, if it's getting to the Supreme Court and they are the supreme rulers of the decision makers of the land, that it would once and for all solve issues. And yet, as we would read the commentary after it, in many cases, it's not a one and done, that it actually opens up some questions that may continue to evolve, which makes sense, and maybe we'll get into some of these cases now as we promised. So there was a story of United States versus Hansen, Supreme Court case about whether a federal law that criminalizes encouraging or inducing illegal immigration is unconstitutionally overbroad, violating the First Amendment right to free speech. So we're talking about constitutional things. First Amendment, certainly a constitutional issue. So as that case progressed, they are saying that the court upheld the law 7-2, which is interesting, pretty good, right? If you're looking at consensus, holding that it did not violate the First Amendment right to free speech. So what is encouraging or inducing an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of law? That's a mouthful. Yeah. Do you want to distill that a little bit?
So again, we can talk about all these cases. In general, I have not read the opinions on any of them yet, so I can't really comment in detail.
Certainly.
But what it seems to be saying is that this type of action, which may violate a federal statute, does not rise to the level of protection under the First Amendment. So there are certain things. Am I correct about what you said?
Yes, they're talking about, well, the words, let me just get this correct. Encouraging or inducing, is that too overbroad? Like aiding and abetting might be in some cases too overbroad, too far-reaching.
Right, but did the court find that it's not protected by the First Amendment?
It's not.
It is not, which that's what I would...
Did not violate the First Amendment.
Right, which is what I would expect it to say is that there are certain things that, certain types of speech, some of which are not protected under the First Amendment. We've talked about this before.
Yes, yes,
Oftentimes it's the example of yelling fire in a crowded theater, not protected by the First Amendment. So what they're saying is this type of action, and if there's a statute that prohibits it, that statute does not violate someone's First Amendment right to free speech, because you cannot commit crimes or do things that put public in danger, or are otherwise, as we say, not protected by First Amendment free speech.
So when they're making these comments, part of it is when they're saying overbroad versus a narrower, what's too narrow, how narrow is narrow, and then there are ordinary, how all-encompassing. So these things, when these reach the Supreme Court, it's not one and done for all times, but in this case, Mr. Hansen and his issue was considered to not be a violation of First Amendment. On another case, it might be, though. So
right. Well,
another one might make it to the Supreme Court.
When you do an analysis of constitutionality, and usually I think of due process analysis or even equal protection, it's different types of tests depending on what's being protected. And you seem to be referring to what we might call a strict scrutiny test, which is the action that is being done an important, necessary type of thing, and is the statute, the way it's drafted, the least narrow that it can be, so that you're not overreaching or making it too restrictive on what you can do. And that probably came up a little bit in your case that came out today on the college admissions.
We need to get into that for a moment. But another one you talk about, the United States versus Texas, the court ruled 8-1, talk about consensus, that Texas and Louisiana could not challenge certain federal immigration enforcement policies in court. Texas and Louisiana sued because they thought that they wanted to block the Biden administration's policy that was saying certain groups of unauthorized immigrants, however else you want to label it, were being arrested and deported. So the state said that you're violating the immigration policy and you're causing us to pay more money to support them and whatever. Well, apparently 8-1 said that Texas and Louisiana did not have a right to challenge certain immigrations. Here's what it is, and I'm sorry if it puts you out and makes you pay a little more money or whatever else, but that provision, you should be deporting every immigrant, not just selecting certain ones. So it's an interesting discussion about I guess, how immigration is playing out and really how specific they want to be about this particular issue.
So again,
immigration is immigration, right?
Correct. Except again, not having read the decision, what
Deep
it
dive.
sounds like to me is a standing issue. And remember, I talked about looking at whether or not the party that's bringing the appeal has standing. And I don't know if that's what that says.
That is what that's, it's precisely what it's about. When I said earlier, I thought we should cover how does something get to the Supreme Court? Yes, this did get to the Supreme Court, but it said that the Supreme Court didn't address the merits of the state's claim, ruling instead, just like you're saying, that their case failed because the states lacked standing to even sue in that regard. But
Right.
it made it to that
Right. But
court.
but sometimes it'll make it because the court reserves the right to determine whether somebody has standing or not. And in that case, it appears that one of the justices who dissented thought there might be standing because there's a dissent. Or what did you say, 8-1?
8-1.
Yeah. So in this particular case, again, my analysis without having read the opinion is that the Supreme Court said that immigration law is a federal issue, and the federal government, the legislature, and the president have the right to determine what the policy will be, the legislature creating a law, and the president enforcing the law, and as the executive. And the states don't have a right to challenge federal law in this particular instance, and so there's no standing.
Good point. One that I would not have expected to pull, except that it was also a current case. It says Coinbase Inc. versus a person named Bielski. It's that a person named Bielski had filed a putative case saying that Coinbase users had failed to replace fraudulently taken money from their accounts. Well, Coinbase has this in arbitration. So now as this plays out, they thought that the district court must stay its proceedings while they called it an interlocutory appeal on the question of arbitrability is ongoing. So why did it reach the Supreme Court? They said instead it shouldn't have. It should go let arbitration play out, not to supersede whatever's going on in that process, which hadn't played out. So why did it even get to the...
What was the decision?
So they said that that they didn't want to get involved in this because it should go back and let arbitration play out and then see what happens.
So the Supreme Court sent it back and said, no decision on this case yet. Arbitration should play out first.
That's what they held.
All right. And so this sounds more like a procedural question as to whether or not the arbitration clause was enforceable. And so the district court apparently, if I understand what you said arbitrate it first. The Circuit Court of Appeals on this interlocutory appeal, because the case hasn't been finally decided at the district court level, said play out arbitration first, and the Supreme Court agreed. I'm not sure, without having read the decision, why the Supreme Court would have even taken that case.
So Coinbase gets to say, we win. We told you this is an arbitration and this needs to play out. So Coinbase wins in that case. Arbitration has to continue.
That's what it sounds like.
So we have talked about this affirmative action for years, at different times. This was considered one of the blockbuster cases. Judgment just came down. Let's play that out. So it used to be that you'd have to make sure that Harvard had they wanted to have diversity. It's a good thing. Mm-hmm. Diversity is a good thing. So now that's changing in terms of how they're going to have to rewrite who gets accepted and when. Care to address that?
Okay. So should we talk a little bit about the history of this type of case?
Set that up.
So I
Sure.
believe it started with Bakke, B-A-K-K-E
yes.
versus California.
And I think it was that 17 years ago? It seems like it was forever ago.
Yeah.
Or was it more recent than that?
Oh, I think it was a long time ago.
Okay. Maybe I'll have it here.
I think I was still in school back then.
Oh, that long ago?
That long ago, so like another century or two ago. And the case that was brought there, to my recollection, is that Bakke, sued because twice he was denied admission to medical school at the University of California, Davis, I think.
78. There we
78.
are.
I was still in school. And so what happened was the court said, well, there was like 8 different opinions from 9 different justices. And the one decision, I forget who wrote it, maybe Powell, I'm not 100% sure. But whatever it is, that was the one that was considered sort of like the key language to this decision. And he went through a number of different things to determine whether or not the policy would pass strict scrutiny, or did it violate equal protection laws and so forth. And the idea was he came with a decision that said, nope, this reason doesn't pass, that reason doesn't pass. The right for the school to have a diverse student body, that needs some protection. And he gave protection for that and said that their policy of looking at as a factor, race, does not violate the Equal Protection Clause, and Bakke loses. And the schools can consider race in admissions. And that case then was reviewed again by a case with the University of Michigan. There was both an undergrad case and a law school case. And the Supreme Court found that one of the admission policies, and I'm not sure which, but let's say it was the law school, which gave points,
Yes.
was not acceptable. That doesn't pass muster. But the other policy, which considered race as a factor, did pass muster, and it was allowable to use that to consider it in order to have a diverse student body. There was some, what I call dicta, which is not the part of the holding, but just some language in the case that talked about, hopefully, precatory words, in my opinion, but maybe not interpreted that way by everyone, in 25 years, we won't need this anymore.
That was one of the justices,
Right.
female, who was it?
O'Connor?
Yes,
O'Connell?
I think that was.
Yep. Yeah, I think so too. Not 100% sure. But the point is that language was in there for whatever it was worth. So that case said you can still consider this, it's still a factor. Now you fast forward to the most recent case. What do you want to tell us about that?
So the court found that it was unconstitutional to consider race in university admissions, and that eliminated one of the tools. So as you were mentioning, diversity doesn't seem like that should ever be a problem, that you'd want to have diversity, because diversity doesn't just mean race. It means you might like to have a farmer who's pursuing a nuclear physicist, becoming a nuclear physicist. So they're just saying no longer are you able to give applicants the boost. So admissions officers now have to decide how racial diversity plays in among other issues like academic performance, for example, and achievement. And why wouldn't they be able to be considered without it just being racial, just the racial boost?
So
Seems that that's reasonable.
Yeah, I'm not sure what they actually wrote in this opinion because I haven't seen it yet.
Eliminating racial discrimination is what they're saying.
Okay.
It means eliminating all of it, says Justice Roberts.
Well, but again, we'd have to look at the decision and see how it dealt with precedent. Because the way a judge, I'll make you a Supreme Court judge in this instance,
Okay.
the way you would want to look at it, making a decision, it would be based not on what your opinion is, but based on the Constitution and stare decisis, which is precedent, which is prior opinions of the court, decisions already made. The University of Michigan case, for example. And how did they deal with that if they differentiated? But here's, without knowing that language and what they wrote, how I would differentiate this case, if you and I are the two judges deciding this case, is in the Michigan case, what they were doing was looking at giving race a factor in the decision, a positive factor.
A positive factor.
A positive factor. We want to include more people of this particular ethnicity. In this case, what Harvard was doing, is the way I understand their admissions process was, they would go through and accept, yep, you made this cut, you made this cut, you make this cut. Now we're going to eliminate some people because we can't accept everybody. And they made race one of the factors in eliminating people. That's negative. And none of the Court decisions ever talked about using race in that way. So if I were deciding the case, I would probably find that the Harvard policy does not pass constitutional muster, not because it considered race, but how it considered race as a negative factor.
So as they refer to it, and this is rip and
It was
read.
this morning.
They talked about Harvard, and then they mentioned also the University of North Carolina, referred to as the two pillars that they were discussing. Yeah. An elite education subsidized by taxpayers for state residents. Both schools said that, consistent with decades of Supreme Court precedent, a minority applicant's race could serve as an unenumerated plus factor that raised chances of admission. So does that now strip away all of that? I don't know what the plus factor is. That what the boost really means now?
So the plus factor would be the University of Michigan saying, we want to have a more diverse class. We have all of these applicants who are all equal, maybe in many ways.
And standards,
but here we're going to take this applicant over that applicant because their race adds diversity. That isn't how I understand Harvard was using race in their admissions in this particular case.
Yes, so now they say they may still want to have a diverse student population, and it may be that they want the farmer who brings to the table academic standards, but also some other very valuable extracurricular, somehow now has some merit, and we're not going to just weigh these two candidates' race versus someone else who also represents diversity.
Well, they might want a cellist or a football player too. So there are a number of factors that they can look at. From a legal standpoint, my interest in this case would be to see how they dealt with prior precedent and what they said about it, and whether they eliminated it or overruled it, like they did with the case that overruled Roe versus Wade, or if they distinguished, which is really, for the most part, that's how the Supreme Court should be deciding cases. Distinguish this case from a precedent that you may not be following because it is different.
And so we won't have time to get into another case, but it had to do with federal redistricting. And it sounded like it settled things once and for all, and yet all commentary about it says the Supreme Court really didn't. They answered one particular question, I guess it was about North Carolina and who was going to get to redistricting. It was a gerrymandering case, and depending on whose ox is gored, we don't necessarily want to have everything upset, and who gets to decide, states versus taking this to the Supreme Court. So the comment was that the Supreme Court actually did solve this case. They made a ruling, but it leaves it muddled. There's going to be more controversy. Will it come up again? Is there another issue about gerrymandering? Is there another issue about what happens to redistricting depending on who's raising the question?
People will often try to probe at different cases as best they can. The one good thing about that particular case was they said that the independent state legislature theory or policy, which the independent state legislature has absolute right to make whatever decisions they want to make, and there is no review, does not really stand.
Thank you for getting into. I didn't think we'd have a chance to set this up because we are out of time. We hope that you found this session about the Supreme Court decisions, and a few yet to be made as of before the end of this session. We hope you found this interesting, and we hope you'll continue to stay tuned to The Law Matters. It matters to you. Thank you for tuning in.